through Twitter, and that's on social media, to abuse, harass and intimidate journalists who publish stories critical of him and the EFF party. The South African National Editors Forum believes that the EFF's alleged actions amount to incitement. Represented by advocate Daniel Berger, SANEF and 5 journalists say that the economic freedom fighters have created an environment that is hostile towards journalists. The matter relates to Malema's utterances outside the Zondo Commission of Inquiry last year, where he accused certain journalists of being part of a Stratcom and of acting as a defense force to President Cyril Ramaphosa. He also allegedly vowed to make the journalists' lives a hell until they start writing favorably towards the EFF. And represented by advocate Tembega Ngugaitobi, the EFF plans to question the Equality Court's jurisdiction and SANEF's authority on this particular matter. SANEF's Mahlase and the EFF's Dr. Mbuyiseni Ndlozi are also present at the proceedings.
The trial of Pastor Timothy Omotoso in the Port Elizabeth High Court has been postponed to tomorrow. The state has not been successful in obtaining a new certificate of authorization from the National Prosecuting Authority.
Last week, Omotoso's lawyer Peter Doberman argued that the previous certificate of authorization for all the charges was in fact invalid. Omotoso's defense team argued that the trial is now de novo and that any prior certificates should not be valid. Doberman wants the rest of the counts to be heard in their respective courts in the country.
All right, and to unpack what's happening in this trial, let us cross now live to our SABC News reporter, Jayed-leigh Paulse. Jayed, good afternoon to you. Thank you so much for joining us. Yet another postponement, this time around, of course, the state not being successful in obtaining a new certificate of authorization. Talk to us about these proceedings.
That's very true, Palisa. I think a couple of days now we've seen the trial being delayed and postponed continuously over certain applications, certain certificates that weren't furnished to the defense, and a lot of also legal jargon. But I do have with me Kuban Chetty, and he's an attorney here in Port Elizabeth, just to break down and unpack what this all means with regards to a certificate of authorization of all the charges on the indictment, the possibility of a bail application for Omotoso, and then also but Omotoso being handed that prohibited document to declare him prohibited in the country by Home Affairs. Kuban, thank you so much for joining us today. Obviously, it's been quite a interesting few days now with everyone watching the Timothy Omotoso case. In terms of the certificate of authorization that the defense is asking from the state to supply, we know that the state wrote to the then former NPA head Shaun Abrahams and they were furnished with it, but now there's subsequently issues surrounding that. Is this a delaying tactic by the defense in your terms, or where to from here? What can we expect, or what do you believe will possibly come out of this?
Good afternoon, Jay. Thanks for having me here. To start off with, maybe we should look at where this comes from. Section 110 and 111 of the Criminal Procedure Act basically governs the situation. 110 basically states that there's 2 scenarios. Number 1 is when the accused does not object to the jurisdiction of the court, and in that sense, even if the court does not have jurisdiction, they continue as if they do. A verdict is given. The second situation is where what we're currently facing is where the accused objects to the jurisdiction of the court. Now remember, the High Court does not have a discretion to say we will hear or we won't hear the case, and that's where the authorization that you were talking about comes in. Now the ex-head of the NPA, Shaun Abrahams, issued such a direction to say that all the charges should be centralized and heard in Port Elizabeth. However, the defense raised some defects in that. And the defects were, for example, the indictment was not attached to it, meaning a list of all the charges in the charge sheet as we colloquially know it. And secondly, the case number wasn't also attached to it. Now, those are defects that the court has to decide, are they material or are they not material enough to disregard jurisdiction? Now, if one looks at the case of Mamase, State versus Mamase, it's a 2010 Supreme Court of Appeal decision. The exact same thing happened where they raised the objection to jurisdiction. in the charges, and the High Court ruled that although there was a defective direction by the head of the NPA, they allowed the jurisdiction to take place and the trial continued. That is immediately appealable because it's a final decision, and the Supreme Court of Appeal held that they did not have the discretion to grant jurisdiction on a defective direction given by the NPA.
Just in layman's terms, for viewers that are watching, what will this mean if jurisdiction is not granted to the Port Elizabeth High Court? Judge Omar Skuman and I suppose the defence, where to from here? What will happen? Will we possibly see the trial being heard in various courts across the country?
Well, actually, one has to look at the logistics of this. You have cases in Secunda and various other areas where jurisdiction can be conferred. Now, are we going to have, out of the 97 charges, including main and alternative charges, are we going to have 5 in one jurisdiction, 10 in another, 20 in another? It just doesn't make sense. And you're not going to have the overlapping of witnesses and a coherent, full logistic trial taking place in a logical manner. So I don't think that's going to happen. If jurisdiction is not conferred by this court, it has to adjourn to the court of jurisdiction, which means 5 or 10 various jurisdictions. I think then the NPA is going to step in and say, let's centralize this in one area of jurisdiction. It's not going to work. Otherwise, I don't see it working.
Okay, and then Mr. Chetty, obviously there's been a lot of talks about a possible bail application on the cards by the defence. Now, we did see Timothy Omotoso being handed a document declaring him a prohibited individual in the country. In terms of bail, how would it work? Should he, for argument's sake, hypothetically speaking, he get granted bail? What would happen?
Well, if he's granted bail, and I think that's the reason why it was served to him at court, as a matter of urgency, I would say, because he was prohibited for a while now. They didn't serve the papers. They did it now because they probably foresaw that with these applications taking place, there might be a possibility of bail being granted, a new bail application on new facts. One of the new facts being the length of time that is spent inside. However, there is case law against that, but we won't delve into that now. The reality or the practical effect of what you're asking is that he will be taken. He's prohibited, so he cannot roam the streets of our country. So he will be taken into a place of custody and probably kept until the finalization of the case. Because if he's deported, one has to look at extradition also, and can extradition work depending on the severity or the severity of the offences. So he'll probably be kept in custody until the finalization of the case, and thereafter decided if he's given a custodial sentence, he'll serve it out in South Africa and then deported. If he's not or acquitted, he'll be deported thereafter.
Very interesting. And then lastly, Mr. Chetty, just in terms of that first witness, Cheryl Zondi, can she decline to, or rather not take the stand once again? Can she actually decline and say no?
Well, yes, she can. She can decline and say this is too traumatic, and the state has to be served with the option of forcing her to come and testify. And they can subpoena her to come and testify. And if she doesn't, it's a criminal, it's contempt of court against, although it would be a bit unfair. And if she doesn't give her cooperation, the state can turn into, or make an application to turn into a hostile witness, or application for a hostile witness, and treat her accordingly. Which isn't the ideal situation in any event. But yes, in layman's terms, yes, she can decline if she wants to.
Thank you so much for your insight there. That was Kuban Chetty, an attorney here in Port Elizabeth, just breaking down the legal jargon, but also talking about that certificate of authorisation by the state to centralise all the charges that's still on the cards. We still have Judge Oman yet to rule on the matter, but also speaking about the jurisdiction. Has the Port Elizabeth High Court got the jurisdiction to, look into all the offences of Timothy Omotoso? You would know that it's 97 charges, 63 main charges and 34 alternative charges. But of that 63, only 7 offences occurred in this part of the world, whereas all the other charges occurred in Mpumalanga, the Western Cape and Secunda. So Judge Omar Skuman will be ruling on that matter tomorrow at 2 o'clock. Palesa, it's back to you in studio.
All right, many thanks there to our reporter Jayed-leigh Paulse reporting live from Port Elizabeth. That case postponed to Tuesday.